The next matter to come before the court this morning is Summit County Sheriff versus the FOP and the Ohio Labor Council. As you know, each party will have 15 minutes to present oral argument. The appellant will proceed first and may reserve up to 5 minutes for rebuttal. If you wish to reserve any time for rebuttal, please let me know as I'm keeping time, and I'll apprise you when you get close to that time. We've read the briefs and we're ready to proceed with it.
May it please the court, Gwen Callender for the Fraternal Order of Police, Ohio Labor Council. Your Honor, may I please reserve 5 minutes for rebuttal?
Yes.
Thank you. This is a case which I appreciate you've read the briefs on involving the review of an arbitration award. And the standard of review today is whether the trial court committed error as a matter of law. The case is a 271110D appeal. And so the issue is whether or not the arbitration award drew its essence from the collective bargaining agreement. The standard of review has been before this court just last year, as a matter of fact, in a case involving the Akron firefighters in the city of Akron. And in that case, this court acknowledged what their standard was and acknowledged that the review is limited. And the roles determine whether or not the award draws its essence from the agreement. And that is a standard that is set forth by many cases that have been decided by the Ohio Supreme Court. And in this case, the trial court clearly committed error when it decided to interpret the contract, and it substituted its interpretation of the contract for that of the arbitrator. And the trial court's order, the trial court judge stated that he concluded in the trial court's order that the term grandparents was ambiguous. And by that determination alone, it's clear that what the trial court did was embark upon interpreting the collective bargaining agreement. The trial court did not determine whether or not the award drew its essence from the collective bargaining agreement. The trial court looked at the facts, looked at the law, and reviewed the merits of the case. And that is clearly prohibited by Ohio Supreme Court precedent, the Goodyear case that's cited in my brief, the Hillsborough case. There's a whole line of cases that have clearly stated that however tempting it may be as a court when you're reviewing an arbitration award, however tempting it is to want to second guess what the arbitrator decided, to want to look at the actual facts of the case, the law of the case, the standard under a 2711D appeal, 10D appeal, is very, very narrow and limited. And it's limited to whether or not the award draws its essence from the collective bargaining agreement. And the trial court simply did not do that. The trial court looked at the facts and looked at the contract language and decided that the trial court judge, was going to interpret the term grandparents. And that's what the arbitrator did. The arbitrator was asked by the parties in a joint issue to determine whether or not Article 24 of the contract was violated. And Article 24 was the bereavement leave article, and there were several provisions in that article, and the parties stipulated to the issue and asked the arbitrator to decide whether or not the term grandparents included not only the employee, but the employee's spouse's grandparents. That's what the parties asked the arbitrator to do, and that's what the arbitrator decided. And the sheriff was unhappy with the result, and that's why the appeal was filed. And the trial court erred as a matter of law when it determined that the term grandparents was not ambiguous. The trial court overstepped its bounds by making that determination. That's a factual and legal determination. That's an analysis that is improper in a 271110D appeal. The test has been repeatedly stated over and over again. Does the award draw its essence from the collective bargaining agreement? And the courts have stated that in order to answer that question, there has to be a rational nexus between the arbitration award and the collective bargaining agreement. And that's in the Mahoney County case that I cited in my brief. It's an Ohio Supreme Court case. Was there a rational nexus between the award and the contract? And you'll note from a review of the trial court's order that he doesn't even get into that. He doesn't determine whether or not there's a rational nexus. He merely looked at the facts and he made his own determination that the term grandparents was ambiguous.
Well, there's some case law that talks about the reviewer being able to look at whether or not the language in the agreement, trying to think of the way that it's phrased, but it seems to me that the trial court was looking at it and saying, this says grandparents, and grandparents is not ambiguous.
That's exactly what he did. Grandparents, as it is used in the context of the collective bargaining agreement, was subject to interpretation. And that's the key here. The term grandparents, who defines that? That's the question. Who defines the term grandparents? As it is used in the collective bargaining context, we ask the arbitrator through a joint issue, please help us define that. Interpret that. That's your job. You're the arbitrator. There's been a grievance filed. We want you to define that term. That's your job to do, not the court in a review. It's so tempting to want to say, but we think it means this. I'm the court, I'm reviewing it, and grandparents seems to be a pretty easy term to define. But if you were at the arbitration hearing and you had the history that the arbitrator looked at, the evidence that was before him, how for the past 10 years, since 2004, the term grandparents, as it's used in the collective bargaining agreement, has always been interpreted to mean the employee and the employee's spouses. Always. And that's in the arbitration award itself. And so it seems it would be, the plain and ordinary meaning is what the judge in the trial court indicated, that it has a plain and ordinary meaning, but the meaning of the term grandparents is in the context of the collective bargaining agreement. That's the context that the arbitrator was looking at it. The cases that were cited for plain and ordinary meaning by the sheriff's office, they cited a case, the IAFF case, that was decided by the Supreme Court. But in that case, the Supreme Court vacated the award because the arbitrator relied on extraneous material to make that determination. And in this case, the arbitrator looked at the evidence of the bargaining history, the testimony of the witnesses at the hearing, how proposals were made during negotiations, and using all that evidence, the arbitrator drew a conclusion, and that's what the parties asked him to do. And when it got to the court on a review, the facts cannot be relitigated. And this court, again, just last year, in that firefighters case from the city of Akron, clearly stated that the facts and the law are not subject to review. And the term grandparents may seem simple, but in the context of a collective bargaining agreement, it had meaning. It had meaning to the parties. It was understood by the union and by the sheriff for at least the past 10 years that it had a certain meaning.
The sheriff cites page 6, the bottom of page 6 of its brief, case United Paper Workers International Union versus AFL-CIO for the proposition that the arbitrator may not ignore the plain language of the contract. And so, in the context of this court's decision looking at the various relationships that, for which paid leave is permitted, and cannot an argument be made that the arbitrator ignored the plain language of the contract in making the determination that step-grandparents should be included?
Well, Your Honor, it was grandparents-in-law, and there was...
I meant grandparents.
Yeah, there was several grandparents, there's several in-laws that were included in that that same article. And whether or not you believe that the arbitrator overstepped and broadened the definition, his interpretation of the contract is what the parties bargained for when we went to arbitration. Whether it's factually correct, whether it was contrary to law, that's not grounds for vacating. And that's the point. We may not agree, a different arbitrator may not have found the same result. A different arbitrator may have ruled differently. You as judges may not find it to be reasonable or may not find it to be something that you would rule upon in the same way if you were the arbitrator. It's very difficult to step back from that, but under this type of an appeal, it undermines the entire arbitration process if arbitrators can be second-guessed. The OCB case, which is cited on the same page, Your Honor, that you just pointed out on page 6, in that case, there was clearly a conflict between the arbitration award and the collective bargaining agreement. In that case, it involved the termination of a employee for the state of Ohio who was caring for mentally retarded people at a home. And she was found guilty of patient abuse. And it went to arbitration, the union appealed it, and the contract language was very clear. If a finding of abuse is made, if the arbitrator finds the employee guilty of patient abuse, he or she cannot modify the penalty. And in that case, the arbitrator found the employee guilty of patient abuse, but modified the penalty. And that's why in that OCB case, cited on the same page, there was an express conflict between the terms of the collective bargaining agreement and the arbitration award. In this case, there is nothing in our contract which ties the arbitrator's hands for making the determination of what the term grandparents meant.
Let me stop you
Yes.
just for a moment because I couldn't recall how much time you...
5 minutes.
Okay, you're into that.
Oh, okay, thank you, Your Honor.
Reserved it for the balance.
Yes, thank you.
May it please the court. My name is Colleen Sims. I'm with the Summit County Prosecutor's Office. I'm an assistant prosecutor and I represent the Summit County Sheriff's Office. I would agree with the appellant as to the standard that is for you to determine whether the trial court erred as a matter of law. What I would disagree with is that the arbitrator's award did expressly conflict with the collective bargaining agreement. The arbiter is confined. There are limits to what an arbitrator can do. Certainly it is not the norm to vacate an arbitrator's decision, but it has happened, and it's happened in the 9th District as well as the Ohio Supreme Court, where an arbitrator's decision has been vacated. It happened in the 9th District case that I cite, Clearview Education versus Clearview Local School District, where there was an arbitration as to who would be available to get the football coach decision. Also another 9th District case, Cuyahoga Falls versus the FOP case that I cited. In that case, as I cited in my brief, the arbitrator's role is one of conformance with the collective bargaining agreement. And it's the sheriff's position that by creating a new definition for a simple word grandparent, as I mentioned in my trial court brief, this is a word that's understood by an elementary school person. And we believe the arbitrator was confined to give that word a plain and ordinary meaning, and he did not, and tried to artfully argue that there was some ambiguity. And I believe the problem with that is when an arbitrator is allowed to go outside the confines of giving words their plain and ordinary meaning, it almost renders the collective bargaining agreement meaningless, that they can give any word a different meaning or claim that it's ambiguous.
But isn't that what the parties, specifically what the parties asked the arbitrator to decide?
The issue that the arbitrator was to decide was, as he stated on page 3 of his award, was whether the employer violated the collective bargaining agreement when it refused to provide bereavement leave to the grievant for the death of her husband's grandfather. The sheriff's position is that in reviewing the merger clause as well as Article 24, that we did not violate the terms of the collective bargaining agreement.
As we look at the trial court's order, the trial court's order and opinion really doesn't speak to whether the arbitrator's decision draws its essence from the CBA. There's no analysis on that point.
I believe that the trial court did follow the law in focusing on the merger clause of the collective bargaining agreement and Article 24 that deals with who is entitled to bereavement leave. There are specific numbers of relations listed in that. He cites to the funeral leave as well as his position that there is no ambiguity in the word grandparent. I believe when you look at the trial court journal entry, he was correct in vacating the arbitrator's award.
When you included funeral leave, was it further qualified as to what funeral the deceased had a particular relationship to the person seeking leave, or was it just any funeral?
It had to be a specific relation, if I understand your question
Yes, so
correctly.
it was defined funeral leave for a, let's say, grandparent, or funeral leave for whatever. Do we have the same problem throughout that collective bargaining agreement in terms of who has the benefit? Not that I'm just curious to see how the agreement speaks about each type of particular leave.
Well, I guess if I could think about sick leave, there are times when someone's allowed to take sick leave for themselves or a member of their immediate family or a parent. That's even more confined as to who you can. You can't generally, under the collective bargaining agreement, have sick leave for your friend. You may have a great relationship with your friend, they may need the care, and you may be able to take other type of leave, but not family medical leave, if that answers the question. I believe this is the only article that has these specific relations, but there are, for sick leave or other types of leave, there are relations referenced as well. And for example, at some point, there, families do go off. Bereavement leave is not allowed for a second cousin. You can take time off, but you're not going to get the specific bereavement leave under Article 24.
Article 24, if I can find it here, appears to have like a catch-all provision at the end regarding a person who fills the role of a parent or something. I'm trying to find it.
I am now looking at it right now.
What does that say?
It says, and I'm quoting from the trial court, it mentions half-sisters, aunts, uncles, nieces, and nephews, and legal guardian or other person who stands in place of a parent. I would argue, and that wasn't arbitrated because...
Well, yeah, that was my question, whether there was any testimony or any evidence presented before the arbitrator that the person whose funeral was in question stood in the place of a parent?
I do not recall that position being made.
It was just more
that-
focused to whether this was a grandparent or a grandparent-in-law. That was the focus.
There was no testimony to my recollection that this person was like a parent to me. And I believe that is more of a situation where someone has brought a child up or is standing in the place of a parent. They wanted to negotiate that situation. The evidence in this case did not, there was no evidence introduced that Deputy Malia considered this person to be like a parent. And I would just, if there are no more questions, I would just end with the position that the trial court did follow the law provided by the Ohio Supreme Court. In particular, Office of Collective Bargaining Agreement versus Ohio Civil Service Employees Association, that an arbitrator's award departs from the essence of the collective bargaining agreement when the award conflicts with the express terms of the agreement. Any evidence of prior allowances of someone to take off time, we would argue was another agreement, but not part of the four corners of the collective bargaining agreement. And in particular, the merger clause specifically states that any past practices are not to be considered. So even if there is some evidence that at one point, we have hundreds of employees, at one point in a prior CBA, collective bargaining agreement, someone was allowed to take time, that's a past practice that is specifically excluded in the current collective bargaining agreement. I would state that the evidence that was presented about past practices, I would argue was a red herring and should not have been looked into. The arbitrator was confined by law and by the collective bargaining agreement to give plain and ordinary meaning to the words. He failed to do so and was corrected by the trial court, who vacated his decision. I will waive the remainder of my time if there are no further questions.
Apparently not.
Thank you.
Calendar, you have 4.5 minutes.
Okay, thank you. The two cases that the counsel for the sheriff brought up, Clearview and Cuyahoga Falls. Clearview involved the football coach. Again, that contract specifically prohibited the posting of a position that was a supplemental position, football coach supplemental position. That's why that was vacated. Same with Cuyahoga Falls. It was a discipline case. The arbitrator relied on a progressive discipline scheme, wasn't part of the collective bargaining agreement. Ninth District vacated that as well. You have none of those facts in this case. In this case, again, the arbitrator was asked to interpret the term grandparents, and that's exactly what he did. He interpreted the term grandparents, and when the sheriff appealed it, the trial judge engaged in a review of the facts and in the legal conclusions, and the trial judge was prohibited from doing that. Your Honor, you hit it right on the head when you said the trial court never determined whether or not the award drew its essence from the collective bargaining agreement, and that is the only question the trial court needed to answer. That was not even done in his two-page opinion. The determination of whether it draws its essence from the agreement is the standard of review. And the merger clause, again, that is a factual argument. That's a legal argument. The sheriff wants to hang their hat on that, and that they presented that to the arbitrator, and the arbitrator analyzed it and disposed of it, and decided that had no relevance to his determination. And now, again, the sheriff is asking this court and the trial court to review that decision, what evidence that the arbitrator considered. And if I could, I would again refer back to the case that was decided by this court last year, the City of Akron firefighters case, cited in my brief. And in that case, the city wanted to object to a piece of evidence regarding the back pay for the firefighter under that residency statute. And this court said, regardless, however, the fact that the arbitrator based his award on this exhibit is not relevant to whether the arbitrator exceeded his powers or exercised them imperfectly under Revised Code Section 271110D. And finally, in that case, this court stated, it is clear that the city disagrees with the substance of the award, but the city cannot obtain a review of factual or legal error with respect to the exercise of the arbitrator's powers by framing its arguments in terms of a 271110D appeal. The city has not provided this court with any argument demonstrating that the award did not draw its essence from the collective bargaining agreement, nor has it demonstrated that the award is unlawful, arbitrary, or capricious. It is not this court's responsibility to construct those arguments on the city's behalf. And we would submit to you that that is what is happening in this case. The sheriff's office is unhappy with the result of the arbitration. And so they have filed this appeal. And they are asking this court to review what the arbitrator considered, the factual and legal conclusions. And the court is prohibited from engaging in that type of analysis. The only question that needs to be answered is there a rational nexus between the arbitration award and the collective bargaining agreement. In this case, there is. The arbitrator was asked to interpret Article 24, the meaning of the term grandparents, and he interpreted that meaning as it is used in the collective bargaining agreement. And therefore, we would ask that this court reverse the trial court and issue an order confirming the arbitration award in its entirety. Thank you very much.
Thank you. Thank you both for your presentations. We'll review the case. We'll issue an opinion to both sides, and by all means do check the Supreme Court website and our website as we post our decisions there as well. Thank you for your presentations. Have a good day.